Okay, good morning, everyone, and thank you for joining us today for an update on legislative changes to data practices and the open meeting law made during the 2023 regular legislative session, as well as a short potpourri. As you know, DPO is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law for members of the public and government. We perform a variety of functions, which are listed here on this slide. If you would like to download a copy of today's PowerPoint right now, I will be sharing the file for you to download and save to your computer. A pop-up window will appear, and then you can select the file and download it to your device. Okay, that transfer window should be available on your screen now. So if you want to take a moment to download that, you're certainly welcome to. I'll also share the slides near the end of this webinar for anyone who joins late or misses the download this time around. So if you don't grab it, don't worry, I can certainly share it later too. You can also find the PowerPoint slides on our webpage where you registered. So that's the webinars webpage. So you can download a copy there as well. It's under one of the drop-down menus, I think the one on the very bottom of that page. So you can also download a copy of the file there too. Okay, so for today's agenda, the Minnesota Legislature wrapped up the legislative session back in May. And as I'm sure you know, there were several large omnibus bills passed and signed into law. During the session, the legislature made several changes to data practices related statutes as well as to the open meeting law. So I'll take the first part of today's webinar to highlight some of those changes. I'll also take a moment this morning to highlight some reminders that you need to update your data access policies, and then we'll also take time to briefly answer some of the questions that our office has seen during the past month or so, and we'll leave some time for a Q&A session at the end of the webinar. So please feel free to send in questions as you think of them using the Q&A panel on your screen. When sending in those questions, be sure to choose all panelists when you send those in so we can be sure to see them. You can feel free to start sending questions now, or you can wait until the end of the presentation. So let's start with reviewing some of the changes the legislature made to data practices and the open meeting law, including amendments to existing provisions, as well as the creation of some new requirements for government entities. As we're going through these changes, I'll primarily be citing the statutory sections that have been amended or added. If you'd like the specific citations to the session laws that made the changes, I recommend looking at the newsletter from earlier this month that we sent out on July 6th, I believe. I have a link to the page on our website at the very end of these slides where you can find the copy of that newsletter if you didn't receive it. I also want to add that the legislature did make a lot of changes to data practices requirements, but many changes affected specific state agencies or sectors of government work. We did our best to highlight all these targeted changes in our July newsletter, and we aren't going to be able to dive into all of those changes today. Rather, we're trying to highlight many of the changes that are applicable to a broad range of government entities. Again, I'm encouraging folks to review the newsletter on our website to obtain a comprehensive list of the changes that were made during this past session. As a final note, today is July 13th, 2023, and most of these changes went into effect this past July 1st, meaning the changes are in place now. However, I'll note any effective dates that you need to know in order to comply with the law. Let's start this morning with some changes to the requirements governing the disclosure of personnel data under Section 13.43, Subdivision 6. First, the legislature updated the language of Subdivision 6 so that government entities have statutory authorization to disclose personnel data with the Minnesota Public Employment Relations Board, which has authority to investigate and resolve unfair labor practice charges and complaints involving public sector employees. The legislature also amended the language of Subdivision 6 so that sharing data with labor organizations is no longer discretionary. Rather, government entities must provide data to a labor union to the extent necessary to conduct elections, investigate and process grievances, and to implement chapters 179 and 179A. However, the language also notes that employee social security numbers are not necessary to implement chapters 179 and 179A, meaning that government entities should not be disclosing social security numbers to labor unions. Lastly, the amended language clarifies that certain data about employees, such as personal phone numbers, personal email addresses, and dates of birth, are private data. Emails or other communications between the labor union representatives and members, prospective members, and non-members are also classified as private data. All right, the next change I want to highlight is a new section in the Data Practices Act that governs licensing data collected and maintained by political subdivisions. So, the legislature has classified data contained in tax returns and bank account statements that a person submits to a political subdivision when seeking a license as private data on individuals or non-public data not on individuals. Additionally, there are new requirements that these tax return and bank account statement data must be destroyed within 90 days from the political subdivision's final decision on the license application. A few notes on this section. The effective date for this section was May 20th, 2023, and the legislature specifically added that government entities must meet these destruction requirements for any tax return or bank account statement data within 90 days from enactment. So, if you are a local government entity and you maintain these types of data, you will want to make sure that you are preparing to comply with this section. Additionally, the fact that some of these licensing data are newly classified as private data means that political subdivisions will now need to meet the various requirements under sections 13.025, 13.04, and 13.05 regarding the collection and maintenance of not public data on individuals. These requirements include providing tenants warnings when asking individuals to supply private data, establishing procedures to ensure that private data are secure and accessible to only employees whose work assignments require access, and updating data inventories to reflect the new classification. In short, if you work for a municipality or a county that issues business licenses or other types of licenses, you will want to review this section closely to ensure you are managing licensing data properly. Next up, we have some changes to section 13.32, which governs educational data. First, the legislature amended section 1332, subdivision 5, to limit the types of data about students that can be designated as directory information. As a reminder, directory information is defined by FERPA as educational data that would not generally be considered harmful or an invasion of privacy if disclosed, meaning that these types of data are public. Schools must specifically designate which types of data are directory information and inform students and parents of these designations. Schools must also offer an opportunity to opt out of such designations. However, the new language of Subdivision 5 prohibits school districts from designating a student's home address, telephone number, email address, or other personal contact information as directory information. As a result, these types of personal contact information will now always be private data about students. Importantly, this change went into effect on May 20th, 2023, and it applied regardless of whether a district previously designated personal contact information as directory information. So, schools should not generally be disclosing this type of contact information about students unless there is informed consent. I also want to note that this provision does not apply to post-secondary institutions, meaning that colleges and universities may continue to designate these types of personal contact data as directory information if they so choose. Finally, schools must still share private contact information with the Minnesota Department of Education for federal reporting purposes. Okay, we're going to stay in section 1332 for a couple amendments the legislature made to subdivision 3, which authorizes the disclosure of private educational data. First, schools may disclose a student's name, home address, telephone number, email address, or other personal contact information to a public library for the purposes of issuing a library card to the student. Obviously, the changes to what types of data could be designated as directory information may have prevented a district from sharing data necessary to obtain a library card. However, this language authorizes schools to share these contact data about students without informed consent in this type of situation. Second, schools may share private educational data about tribally enrolled or descendant students with federally recognized tribal nations to the extent necessary for the tribal nation and school to support the educational attainment of the student. Again, these are two new situations when schools have statutory authorization to disclose private educational data about students without first receiving informed consent from students or their parents. Let's now turn to a few new provisions that affect law enforcement agencies. First, the legislature made changes to Section 13.825 governing data from portable recording systems, also known as body cameras. Specifically, there are new requirements in Subdivision 2 for disclosing body camera data that document an officer's deadly use of force. So, if an individual is killed as a result of a police officer's use of force, the law enforcement agency must allow the deceased individual's next of kin, the legal representative of the deceased's next of kin, and the other parent of the deceased's child to inspect body camera data documenting the fatal incident within 5 days of a request. However, the agency may deny access if there is a compelling reason for why inspection would interfere with a criminal investigation. If the agency denies access, it must provide a prompt written denial and inform the requesters that they can seek to compel disclosure through a district court via the process described in Section 13.82, Subdivision 7. Additionally, law enforcement agencies must disclose body camera data documenting a deadly use of force incident to the public within 14 days after the incident. The agency may not redact more than what is required by law, and the agency may withhold public access when it asserts in writing that the public classification would interfere with an ongoing investigation. The legislature also added language to Section 13.825, Subdivision 3, that requires law enforcement agencies to indefinitely retain body camera data that document an officer's use of deadly force. The legislature also made changes to Section 626.8473, which establishes the requirement for law enforcement agencies when purchasing body cameras and implementing policies and procedures that govern the use of those cameras. Specifically, the legislature made several changes to Subdivision 3, which describes what information must be incorporated into a law enforcement agency's written policies. First, there is new language that the written policy must require compliance with its provisions. Additionally, the written policies must now prohibit the alteration or destruction of body camera data or related metadata before the applicable retention period expires. Officers must wear body cameras at or above the midline of their waists in a position to maximize the body camera's ability to record the officer's activities. Mandate that officers wear and operate cameras in compliance with written policies when carrying out official law enforcement duties, and implement the new requirements under Section 13.825 regarding providing access to data documenting a deadly use of force incident by a deceased individual's next of kin and to the public. Additionally, the legislature added language providing the Peace Officer Standards and Training Board with authority to inspect state and local law enforcement agencies' body camera policies to ensure compliance with Section 626.8473. The board also has authority to issue licensing sanctions or seek an injunction against a licensee or agency that fails to comply with this section. Speaking of the Post Board, the legislature also made changes to Section 626.8457 regarding the board's authority to obtain data when it is conducting its investigations concerning a licensed officer accused of misconduct. Under a new subdivision, the chief law enforcement officer, city, county, or other public official is obligated to cooperate with the post board's investigation into an allegation of a licensee's misconduct, as well as with any data request from the board. The chief law enforcement officer or public officials must provide the board with all public and private data about the alleged misconduct of a licensed officer upon request, which can include data related to pending or final discipline or arbitration proceedings, any settlements or compromises, and any investigative files, which can also include body camera or similar audio and video files. Confidential data must also be disclosed to the post board when it specifies that such data are necessary to fulfill its investigatory obligations related to allegations of misconduct. However, the chief law enforcement officer or public officials do not need to disclose data to the board when there is an active criminal investigation or active criminal proceeding regarding the alleged misconduct, or when an active internal investigation exists regarding the alleged misconduct when the request is made. However, the officer or public officials must disclose data to the board upon completion of the internal investigation or once 45 days has passed since the request, whichever occurs first. All right, I do want to briefly highlight a few other changes that may be a bit more broadly applicable to government entities across the state. First is an amendment to Section 13.72, Subdivision 19, that classifies transit customer data that are collected by telephone or through third-party software third-party software programs to book and use public transit. These are classified as private data. Obviously, this private classification applies to data collected by Metro Transit, but it also applies to any government entity that is collecting data from customers via telephone or some other software related to public transportation use. As a reminder, these data are now private, so the requirements involving data inventories, data protection, and tenancy warnings apply if your entity is collecting data from transit customers via phone or other similar application. Next, I want to highlight the fact that there have been some changes to laws governing expungements, which essentially seals law enforcement records and prevent them from being disclosed. Specifically, Chapter 52, Article 7 of this year's session laws include the creation of automatic expungement of law enforcement records in different situations. Additionally, Chapter 63, Article 5 creates processes for the automatic expungement of specific low-level cannabis offenses, review processes to expunge more serious cannabis offenses, and private classifications for communications related to individuals whose offenses were expunged. Lastly, I want to highlight that the legislature has given more authority to local law enforcement civilian oversight councils under Section 626.89, Subdivision 17. If political subdivisions have these councils, they now appear to have more authority to investigate police officer misconduct and recommend discipline. For data practices, the legislature has indicated that the data collected, created, received, maintained, or disseminated by these civilian oversight councils are personnel data and governed according to Section 13.43. All right, I have just a couple more slides related to legislative updates. And the first one up is some changes that the legislature made to the Commissioner of Administration's authority when it comes to the Data Practices Act more broadly. These were changes that our office were advocating for to help more make the work that we do a bit more efficient. One of the changes that the legislature made is to the data challenge and appeals process described in Section 13.04, Subdivision 4. As a reminder, this subdivision allows data subjects to challenge data about themselves that they believe are inaccurate or incomplete. The amended language now requires a responsible authority to inform a data subject that they have a right to appeal when the data are determined to be accurate and complete. Previously, there was no affirmative obligation to inform data subjects of the right to appeal a responsible authority's determination to the Commissioner of Administration. The legislature also provided the Commissioner of Administration with the authority to dismiss an appeal without first attempting informal resolution or ordering a contested case hearing. However, the Commissioner's power to dismiss is only available if the appeal was not submitted within 60 days of the responsible authority's notice of a right to appeal. The appeal concerns data previously presented as evidence in court, or the individual making the appeal is not the data subject of the disputed data. The second set of major changes was to Section 13.072, where the legislature removed the language that required opinion requesters to pay $200 for an open meeting law advisory opinion. As a result, there is no longer any cost to request either a data practices or open meeting law advisory opinion. Additionally, the legislature updated the language of Section 13.072 to clarify that the commissioner has 50 days after the receipt of a request to issue an advisory opinion. Previously, the commissioner had 20 days to issue an opinion, but could extend that deadline for an additional 30 days for good cause. This extension was always used, so this change simply codifies DPO's already existing business practices and doesn't extend the timeline of the opinion process. Okay, the final legislative change I'm highlighting today is to the open meeting law. Specifically, the legislature deleted the language in Section 13D.02, Subdivision 1, that limited local public body members' ability to attend meetings remotely from a location closed to the public when advised to do so by a health professional only to times when a Chapter 12 state of emergency was in effect, or in the 60 days immediately after the removal of the emergency. In other words, local public body members can now attend a meeting remotely in a private location when a healthcare professional advises them to do so, and there no longer needs to be a state of an emergency for this provision to apply. However, the number of times that a local public body member can attend from an inaccessible location still remains limited to 3 times in a calendar year. In short, this change isn't free rein for local public body members to attend meetings remotely from private locations. Rather, the change adds more flexibility for situations when a public body member may attend remotely from inaccessible locations due to health reasons, but there are still limitations to the number of times when this may occur. So that was a very brief recap of several different changes to the law involving data practices and open meetings that were broadly applicable to many different government entities. Again, I couldn't highlight every change because there were so many, and we do have a comprehensive list of changes available in the newsletter on our website. So now at this point, I am going to shift gears to provide reminders about some Data Practices Act requirements regarding different procedures and policies. So, Section 13.025 of the Data Practices Act requires all government entities to create and maintain policies regarding access to public data, as well as the rights of data subjects. In other words, your entity needs to have a data access policy for members of the public, and a separate policy describing data access for and the rights of data subjects. The law also requires these policies be reviewed and updated by August 1st of each year. So this is a friendly reminder from DPO to take a look at your access policies and update them to reflect current data practices, staff, and processes. Our website has sample policies and a guidance worksheet to help you consider different factors as you update your policies. I'm going to share my screen and show you where those sample policies and worksheets are on our website. Okay, so this is the Data Practices Office website, and we are on the home page here. And from here, when you're looking for the sample policies, you can go to Data Practices, Rules and Requirements, and then down to Policies. On this page, we do have the various documents for model access policies, so a model policy for the public, as well as a model policy for data subjects. In addition to these model policies, we do have a worksheet that you can work through that gives the decision points that you need to make as an entity when developing these various policies, such as how you're going to charge, who are your designees, those types of different things that we really can't explain in the model policy. When it comes to adopting these model policies, if your entity does adopt it, you do need to notify our office, notify the Commissioner of Administration via our office that you have adopted the model policies. And so just a reminder, needs to be done by August 1st. While we're on this page, I do also want to highlight the data inventory. We do have an example of the Department of Administration's data inventory for you to take a look at. Remember, this is another document that you're required to maintain under 13.025, and this document does need to be updated annually also. So it may just be a good practice to update your documents, both the policies and your data inventory, by August 1st of each year. And especially for those local political subdivisions, counties or cities, maybe even school districts. If you are maintaining new types of private data because of a change in the law, you would need to add those private data to your data inventory. So just kind of a reminder to update that as we are moving along here and updating your other policies by August 1st. One last note I do want to make here is that is to remind you that your policies need to be easily accessible to the public, which is a requirement under the law. One of the easiest ways to do this is by posting your policies on your entity's website. So if your data access policies aren't on your website already, this may be a good opportunity to make that suggestion. And I'll just tell you that that is a really helpful process to do for both the public, so they know how to request data, as well as the folks in the data practices office, our office here. Because if we do ever have questions about how you're responding to a data request, or a member of the public has concerns, oftentimes the first thing we'll look for is your data access policies. If that's available on your website, that just makes our jobs a little bit easier. So just a good reminder that you do need to make those policies easily accessible to the public, and your website is a great way to do that. Okay, so we're going to turn now to just a few questions that the Data Practices Office has received in the past few months that we wanted to highlight for a wider audience. Okay, for our first question, we did have a situation where a records manager in a city received a court order which was signed by a judge. That order directed the city to disclose both public and private data to a county sheriff's office. The records manager had not received a court order previously, so the question for us was, what should we do in this situation? So, court orders do not affect the classification of data. However, a signed court order from a judge may be sufficient to disclose not public data. But the exact language of the order matters for what types of not public data may be disclosed, or whether the data should be disclosed at all. So, anytime you receive a court order, the first step that you should take is to check in with your entity's legal counsel to help you understand and review what specific data that is ordered to be disclosed. From there, you should determine the classification of the data that is the subject of the court order. Any public data can certainly be disclosed in response to the order because those data are accessible to anyone for any reason. However, if the order directs disclosure of not public data, then you will need to work with legal counsel to determine the appropriate response. If your entity determines that it is appropriate to oppose the order, then your entity's attorney will need to follow the procedures described in Section 13.03, Subdivision 6. Under that section, the legislature has provided direction to the appropriate presiding officer about how to determine whether disclosure should be compelled. I've also included a link on this page to our website that provides guidance on how the Data Practices Act interacts with courts, including how to respond to court orders. The second question we have is similar to the first, but here we are discussing subpoenas, which are different than court orders. So, a law enforcement agency contacted our office to explain that it had received a subpoena related to a civil lawsuit that asked for all data from an inactive criminal investigation, including any body camera data, which were classified as private data, that the agency maintained. So, the agency's question for us was, what should we do when we receive a subpoena from an attorney especially when the subpoena requests disclosure of private or confidential data. As I've already noted, subpoenas differ from court orders, and they do so in a few different ways. Subpoenas do not come from a judge, and they do not carry the same legal authority as court orders. Rather, subpoenas typically come from an attorney representing a party in litigation where the government entity is not directly involved. In short, a subpoena does not typically carry the authority to disclose not public data. So, here are the steps to respond to a subpoena. First, you should contact your agency's legal counsel to review the subpoena and to understand the types and scope of data that the subpoena is requesting be produced. From there, you should review any responsive data and determine the classifications of the data. If the data are public, you can provide the data because, again, public data are accessible to anyone for any reason. However, if there are not public data that are responsive to the subpoena, then you cannot disclose the data and should move on to the next step. Specifically, you will need to rely upon your legal counsel to oppose the subpoena under either the Minnesota Rules of Civil Procedure or the Minnesota Rules of Criminal Procedure, and the appropriate process depends on the type of subpoena your entity has received. In short, you'll want to be working with legal counsel closely to help oppose disclosing not public data. Lastly, this process may be different if your entity receives a federal administrative subpoena or a federal grand jury subpoena. Processes for when the subpoena involves educational data can be different too. You can find more information about subpoenas in these types of situations via the link on this page. Additionally, I've noted an exception that some forms of authorized statutory sharing may come in the form of an administrative subpoena from a state agency. Again, the specific language of the subpoena matters, and you'll want to work with legal counsel to review whether a statutory section authorizes the disclosure of not public data and whether that's cited in the subpoena's language. Ultimately, the big picture takeaway here is that anytime your entity receives a court order or a subpoena, your first step should be to contact your entity's legal counsel. Your legal counsel can help you review the court order or subpoena before navigating the next steps in these processes. Okay, one more question before we turn to the open Q&A. We had a representative for a school district reach out to our office to explain that the district had conducted a survey of all its employees about ways that the district could improve its administrative structures. After the survey was complete, several school board members asked the superintendent to provide them with the raw data responses to the survey. However, the survey responses contained identifying information that connected staff members with their responses, which made the data private under Section 13.43, Subdivision 7A. So the question that the school district had for us was, can school board members access the raw data responses that were classified as private under the Data Practices Act? So the answer to this question isn't one where there's going to always be a yes or no answer, and it does require an entity to do some analysis. So I'll walk through these considerations. First, when it comes to who can access private data, or any not public data for that matter, it's helpful to take a look at the language of the administrative rules governing data practices, as well as Section 13.02. Under Minnesota Rule 1205.0400, Subpart 2, private data are accessible to individuals within the entity whose work assignment reasonably requires access to the data. So there are two primary prongs of consideration in this language. First, are the elected officials within the entity? In most situations, it's probably reasonable to conclude that elected officials, such as school board members or city council members, are within an entity due to their roles in the governance and leadership of an entity. However, that's up to the entity's determination. The second consideration is whether the elected officials have work assignments that reasonably require access to the private data. Employees and other individuals within a government entity cannot access not public data simply because they are curious or interested in the data. Rather, there does need to be some work-related purpose before staff and other officials are able to access not public data. So, if the responsible authority at an entity determines that elected officials are within an entity and have work-related purposes to review the private data, then it seems reasonable that elected officials can access the private data. And just as one last reminder, the elected officials would be bound by the Data Practices Act's requirements related to not public data, meaning that the officials should not disclose the data to others without appropriate authorization. So those are our questions today. Let's take a look at some of yours. Remember to send those questions to all panelists so we can make sure to see them. Uh, as you're sending those in, just a few reminders on this slide that the slide deck is available on our website and you can access the recording on our YouTube page in the next day or two. I'm also going to be putting an evaluation in the polling panel in a few minutes. If you'd please fill that out and let us know how we did, what other topics you'd like to see in the future. And I'll also quickly display the slides for download once again. So I'll do that first, and then in just a few minutes, I will highlight that poll to let us know how we did. And so from here, I will turn it over to the Q&A.
We have a question about medical data that's obtained directly from a healthcare provider. In Minnesota, we have the Minnesota Health Records Act, which states that any data obtained directly from a healthcare provider cannot be redisclosed without consent from the patient or the person who's the subject of those health records. The question is, what happens if that data appears in an incident report? So a law enforcement officer's incident report. I think here's important to note, if it's obtained directly from a healthcare provider, verbal or written, the data cannot be redisclosed. And so I think that in those situations, the entity would need to have some sort of process in place to make sure that it's not included in something that would be redisclosed in the event that there was a data request for the incident report or some other public law enforcement data. You'd want to make sure you're noting that that information was obtained directly from a healthcare provider, and whether or not you've received that consent from the patient to redisclose that health information. But something important to remember is that it's only for the data obtained directly from that healthcare provider. So if a law enforcement officer is obtaining information at a scene and there's witnesses and victims that are providing their own healthcare data or own healthcare information or records, that information is not covered under the Minnesota Health Records Act and can be considered law enforcement data under 1382 and addressed like any other law enforcement data. And so if it's in that narrative summary, that's generally one of the public data elements as a brief reconstruction of events, that is likely going to be public. So this restriction is just limited to records obtained directly from a healthcare provider.
Okay, we have another question. How are suicide notes classified? Are they considered medical examiner data or law enforcement data? That's a good question. My answer is it depends, which is maybe not very helpful, but depending on how the data are maintained, who has the data. So if law enforcement, I think, has that suicide note and it's part of maybe their investigative data, that would be classified under 1382. If the medical examiner is part of their investigation, has a copy of that data, it would be classified under 1383. I think it is possible that the data may have different classifications depending on who has it, for what reason, and where they are in the examination process. So if you want to chat about that situation a little bit more, happy to discuss, please feel free to reach out to our office, but it could be under 1382 or 1383.
I do want to just hop on here for a moment to let you know that I will be just opening the poll in just a moment. And we do have a lot of questions hanging out there. We will do our best to answer the ones that we can now, but if we don't get to your question, we will certainly mark it down and then follow up with you in the next couple of days with those answers too. So we certainly see all the questions, but we might not be able to get to all of them because we are running short on time, but we will follow up with you if we don't get to it.
There's a question here asking what was the name of the item listed on our reminder slide. I think you're referring to the update, the annual update for your data access policies. They need to be updated by August 1st of every year. And then we have model policies on our website that you can refer to while updating those if you'd like.
Okay, another question here. A city had a request for permits issued in connection with an event that took place at a city park, and the city has an agreement with a third party who operates the park and issues the permits in connection with these events. So is the government entity, the city here, obligated to obtain any permits issued by the third party managing the city space? So I would look to 1305 subdivision 11, which really talks about the obligations for government entities that are entering into contractual agreements with private parties to perform government functions. So here it does sound like the city has contracted with a third party to sort of manage the permits for these events. The city is the one who has the obligation to respond to the data practices request. So the city would be working with the third party here to obtain the permits so that they could provide the permits in response to the request. So I would say the city has an obligation to work with that third party provider to obtain the government data so that they can fill the request.
Okay, we do have another question here that if a business receives a grant, would the data submitted be governed by 13.599, which is the section on grants, or would it be governed by 13.591, which is the section on business data? That's a great question. And typically you need to look at, the context of the grant. Most likely, it's probably going to fall under 13.599 when there is an application for the grant or even the grant process where maybe it's just provided to particular businesses. And so you'd want to read the definitions and kind of look at that process under subdivision 2 and subdivision 3 in 13.599. Alternatively, there is explanations of the different types of benefits that businesses may receive under subdivision 1 or 2. And then additionally, if the business is a vendor or providing some sort of services, that's subdivision 3 under 13.591. But if it's a grant, most likely you're going to be sticking with 13.599 with some exceptions. But if you have a particular situation in mind, certainly feel free to reach out to our office and we can take maybe a little bit closer look and help you kind of figure out which section may apply.
We have another question asking about whether the Minnesota Health Records Act applies to information obtained from a medical examiner's office. So the medical examiner data actually has their own provision in 13.83. And so I'd refer you to that section when you're evaluating data related to a deceased individual that's maintained by the medical examiner.
Okay, we have one more question that we'll hit here because it is about time. But meetings conducted under 13D.015 require that all votes are conducted by roll call. However, I saw in the previous presentation that if all board members are physically present at the meeting location, but interactive technology is still being used, the votes do not have to be by roll call. Can you confirm this? That's generally correct. If interactive technology is being used to broadcast a meeting where all of the members are present, that's not technically a 13D.015 meeting. That's just a general open meeting. You're just happen to use technology maybe to make the meeting a little more accessible to the public or broadcast it out. Those 13D.015 requirements only apply when members of the public body are attending by that interactive technology. And so when all members are in person, there's no requirements that you need to meet under 13D.015. You'd be meeting the general requirements under 13D.01 that apply to just kind of regular meetings or possibly special meetings, depending on the situation. But yeah, when all members are in person, those 13D.015 requirements do not apply. And so with that, we will pause there. I do want to say thank you for attending the webinar today. As I've mentioned throughout our webinar, you can find a copy of our newsletter on the website. I've provided a link to the specific page on this slide at the very bottom there. Additionally, we will be taking a few months off or so from workshops and webinars as our office is working to update our various trainings to reflect the changes in the law and to generally freshen the trainings up. But if you're signed up for our email list, you'll get all the announcements as soon as we schedule new trainings in the fall. You can sign up for our newsletter on the website. Thank you again for joining us and have a great day.